here in Louisiana and to a lesser degree in Arkansas and surrounding states. We insure about 60 to 65% of Louisiana's doctors. People who work for LSU are insured through the state and do not get insurance through LAMMICO, but LAMMICO is the predominant insurer for all of the private practice doctors in Louisiana. They're here today to educate us about the basics of medical professional liability insurance, risk management for you means holding complications down. Risk management to LAMMICO means preventing you from having lawsuits. And once you have a lawsuit, providing you adequate defense in the cases in which you are not guilty of any infraction. So we have Ron Kennedy here today. Ron has been in risk management with LAMMICO for longer than he would want to admit.
Yes.
He is now retired. If you ask Ron what he does for a living, he says he's a consultant. Well, I have a lot of friends being around my age. When they retire, they are humbled by the fact that they don't want to admit that they don't do anything. So they call themselves a consultant. A consultant is somebody who I think does a lot of honeydews and plays a lot of golf. But Ron would say he's a consultant, and the simple fact that he's at the podium today would indicate that he does still work some for LAMMICO and others. He's with him today are a marketer, Karen McGinty. She works out of the Shreveport office for LAMMICO. And Diane Fricker is a risk manager, probably picking up some of the slack that Ron left vacated when he became a consultant. So we'll have a presentation today that will be relatively short enough that there will be question and answer period at the end. Ron, we do appreciate your coming. And so this is an audience of medical students, third year residents, varying years, have been here since medical school up to as much as 5 or 6 years, and faculty scattered about the room as well. So thank you for coming.
Thank you, Dr. Griffin. I appreciate it. And you told the whole story about my consulting career. That's right. I'm just trying to look busy so my wife doesn't give me something else to do. Thank you again. I always enjoy coming to the medical school because you young folks, I actually get energy from you all, and at my age I need energy, okay? So it's really great to see you. I want to give you some good ideas on how to avoid medical malpractice claims. You know, in your professional career, there's a lot of high points, a lot of things you look forward to. I know this group right here, you look forward to getting accepted to medical school. You worked real hard to get to that point. That was an exciting point. Then you look forward to getting the match to where you wanted to go into residency. That was a high point. I've been around on match days when the residents are finding out where they're going, the students are finding out where they're going. That's an exciting point. And of course you look forward when you finish residency, so the cash flow starts coming this way instead of going, that way. And that's a high point. But how many of you look forward to your first medical malpractice suit? That's not a high point. That's a major bummer. That's a low point. The best way to win a medical malpractice claim is to never have one. Okay, that's the best way, and that's what risk management is about. That's what I'm going to try to give you some good ideas, something that you can use. And the best time to start practicing good risk management is right now, before you get out and get super busy. And I know you're super busy right now, but get out in your own practice. This is the time to start those good habits. I'm going to give you some examples of things that a lot of these case scenarios came right out of our LAMMICO files, but I want to talk to you. Any good risk manager is going to talk about two things: communications and documentation. So we got to talk about that. Here's some communication advice. There was a study done by Livingston and Gallagher about no-claim physicians. These physicians, this cadre of physicians who had been in practice for 10 years or longer and never had a claim. Wow, depending on what class you're in, if you're a neurosurgeon, on average, you're going to get a claim about once every 10 months. That's on average. So, but here by the way, we had a neurosurgeon many years ago who retired who never had a claim, and he practiced. He had a very busy practice. But what was the characteristics of these non-claim surgeons or these non-claim physicians? Well, first they used more statements of what patients could expect from their visit or treatment, that dialogue with the patient. They tended to laugh and use humor more. Now, I don't expect you to be a blue-collar comedian, but it humanizes the relationship between you and your patient. They sat down when they talked to their patients instead of standing over their patient. They actually took time to sit down and get on an eyeball-to-eyeball level with that patient. It humanized the relationship. Very, very, very important. More discussion time with the patient. They spend on average 3 minutes more than the average. And I know time is money, and especially right now, you're going from one clinic to the other. You've got so much to get done. I promise you, when you get out in private practice, it's not going to be that much different. But taking those 3 minutes, extra minutes, made a big difference, because 3 minutes spending with your patient can be an enjoyable, professionally rewarding time. Days and days and days spent in court, well, nothing rewarding about that. They encourage their patients to talk, and they frequently check with the patient's understanding. Remember, we're patients. We don't understand medicine. You understand it thoroughly. I mean, I trust you. That's why I came to you to do my surgery. I trust you. I know you understand it. I don't. You've got to make sure I understand what you're telling me. So you frequently check back, and then as you leave, okay, Ron, we talked about your surgery now. This is what I understood you was worried about. We talked about that. Anything else we need to clear up before I leave? No, Doc. Great. Wonderful. These communication skills will serve you well in avoiding the claim. Poor communications, well, patient's discussion done in an insensitive manner or not at all results in a deterioration of that physician-patient rapport. That rapport is your frontline defense against a medical malpractice claim. I had an old doctor up in Morehouse Parish. Anybody know where Morehouse Parish is? Yeah, one person knows where Morehouse Parish is. But anyway, he came up to, he had a bigger Mississippi accent than me, and he was in his 80s at the time. I did one of my risk management presentation, Dr. Baker, you remember him, and he came up to me and put his arm around me. He said, Ron, I want to tell you. That's exactly what he said. I want to tell you, if your patients love you, they won't sue you. He'd been in practice up in Morehouse Parish for, what, 40 years? 50 years, never got a claim. About, a year before he retired, he got a claim. Yes, sometimes even when your patients love you, you'll get a suit, But the interesting thing is, because they had great respect for him, we were able to settle that claim a lot easier. The patient wasn't angry with the physician. Very, very important. A surgical closed claim study, y'all may know the footnote number 12 down there. I don't know if y'all know that, gentlemen or not. A great study. But one of the things that we as risk managers, when we looked at it, was we noted that the study showed that it increased malpractice risk when bad outcomes are associated with poor communications. Very, very important. Here's sort of your algebraic formula. Poor communicating physician, adverse outcome. So you add those two together, put an equal mark, high probability of a claim. Now, if you are a poor communicating physician, you don't do a good job, you don't develop the rapport with your patients, and you never have a bad outcome, you'll probably never be sued for being a poor communicator. You won't have very many referrals, you won't have patients coming back to you, but you won't. But it's when that adverse event occurs. Now, I didn't say when you practice negligently. I didn't say when you breach the standard of care. No, I say when you have an adverse outcome. When you do your informed consent process, there's certain known risk factors that may occur even under perfect conditions. Well, guess what? When those known risks occur and you're a poor communicator, high probability of a claim. That's why communications is so very, very important. Also, having discussions with your patients and disclosures when there's a bad outcome. You need to talk to them, the patient. The apology or the I'm sorry process done well will help avoid legal claims. We'll talk about that in just a minute, about the apology or the I'm sorry process. Now, it's important that it helps avoid legal claims, but this I'm sorry, when you've had a bad outcome, you go to a patient and you say, I'm so sorry for what you're going through. Not, I'm sorry what I did to you. No, you don't say that. And you may be beating yourself up over the situation. You know, as professionals, we always go back and double check ourselves, but you don't have all the information yet. You don't know what all was involved yet. Don't put on the hair coat and start flogging yourself, no, especially in front of the patient or the patient's family. But this disclosure, this apology, this I'm sorry process is important not because it lowers the possibility of a claim. That's important, but it's important because it's the right thing to do. If I jostle you in the hallway and cause you to drop your books on the floor, what's the expected thing for me to do? Oh, I'm sorry, pardon, I'm so sorry. Even help pick up the books maybe. But at least socially we expect an apology when things like that happen. In medicine we tend not to do that. Historically, it's not necessarily the physician's fault. And no one enjoys these things, but it's not necessarily the physician's fault. The very environment of healthcare law sort of puts you in this bad situation because your insurance company say, if you have a bad outcome, you've got a mad patient, don't talk to anybody without first talking to me. And your lawyer would say, don't talk to anyone without me being present, because anything you say can and will be used against you. Sort of like that Miranda thing in the criminal world. Well, that's why we passed the apology legislation, so you can have that discussion. We'll talk a little bit more about that. You've got to be able to communicate bad news when you have this unanticipated outcome. And again, I'm not necessarily describing negligence or breach of the standard of care. It's that known complication that, hey, it finally occurred. You do enough XYZ surgeries, there's certain known complications. You do enough of them, sooner or later, you know, you're going to run across an aberrant nerve or something that went wrong, and it was a known complication. So you have to have that discussion. Explain to the patient and the patient family what went on, what happened. So what's the first questions they want to know is, how did this happen? Be very careful. Most of the medical errors in healthcare systems today is a system or procedural error. A lot of things has got to go wrong before that patient is operated on the wrong side or the wrong knee or the wrong medication given, et cetera, et cetera. So don't be too quick to start placing blame. You can't. But the patient will want to know, and you've got to be able to tell them. We have a committee that's looking into this, our quality committee, our risk management committee, whatever committee is looking at it. We're doing an investigation. It's going to take about 6 months probably to complete all of our investigation, but we'll let you know what processes failed us in this situation and what we're going to do to correct it so it doesn't happen again. That's so important. That patient wants to feel like, well, I'm suffering, but I don't want anyone else to suffer. You know, at least something good will have come out of this situation with me. So how did it happen? What's being done to correct the problem I now have? How will this affect my health short term right now? I might have to stay a couple of extra days. I might have to go back in to have a redo surgery. What's going to be? And will there be any long-term ramification from this? And then, of course, am I going to be responsible for the cost caused by this untoward medical event? Very important that you talk to, if you're in an institution, that you talk with your risk manager, or director of nursing, whoever's in charge, your department head, whoever's in charge of the financial side, and have that answer ready for the patient, because invariably they will ask that. Discuss as soon as possible, don't delay. Take time, turn your cell phones off, don't do it in a rush. A rushed discussion, disclosure of an untoward event is worse than none at all. Direct the discussion to the medical care. Sometimes the patients say, well, whose fault is it? Well, number one, we don't know whose fault it is, and it's not our job to determine fault. It's our job to determine where did our process break down, and that's going to involve a lot of departments, a lot of personnel, not just the surgeon, not just the physician. So we don't know about that now, but let's talk about what your health concerns are going forward, how this is going to affect you, and what we're going to do. Again, avoid discussion of fault. There's legal reasons, which I'll discuss in just a minute, why you want to avoid whose fault it is in finger pointing. Don't be defensive. Watch your body language. Sit. This is a time you definitely want to sit eyeball to eyeball. You want to humanize this relation as much as possible. Yes, you're in charge. You're the one directing the patient's care. You're the MD. You're the authority figure, but you're bringing yourself down to that patient's level, making a human contact with that patient. You can end up, after this discussion, having a stronger relationship with your patient than before that untoward event occurred. I'm sorry protection. This is the Louisiana. Now there's about 38 states, so depending on what state you go to, find out when you go, talk to your risk manager, your department director, what's the I'm sorry legislation in this state? Do we have it in this state? Most states will not protect admissions of fault, admissions against your interests, but they will protect the discussion where you say, I'm sorry for what you're going through. This certainly isn't what we had expected. This is certainly not what we had intended. But if you say, I'm sorry I did this to you, I really messed up, that's an admission of fault. That can be used against you in court. The discussion, the I'm sorry discussion, otherwise when you avoid that, cannot be subpoenaed, deposed, and used against you at court. That's why we made this protection. Again, years and years ago, well I say years, about 5 years ago, our lawyers would tell us, don't talk to anyone without me, the lawyer being there. I'm not a lawyer, so don't throw anything at me, okay? But don't talk to, well, what does the patient think when you've had this good relation with the patient for all this time, you had a bad outcome, and now you won't talk to them? Just from a human, what would you think? Hiding something, right? You know, he feels guilty. He don't want to talk, or she's guilty. She don't want to talk to me. So, and again, it was the environment of the medical legal environment that we who are not physicians created that put you, the physician, in that position. But I'm very proud to say we passed this law, so now you can have that empathetic discussion with your patient. This is some examples. I love this. Came right out of our file. 22-year-old patient had a difficult delivery by a physician not known to her. Healthy child, everything come good. She had some tears. Postpartum, she went to a regular OB, and in the process of checking and seeing the tears and laceration, the physician said, "What on earth did she do to you?" Well, the patient then took this and went straight to her attorney, filing an action, citing her physician as an expert witness who's willing to testify against the other physician. So be careful what you say in front of the patient. We call this jousting. Y'all know about jousting in the old medieval times when they knights would blunt their lance so you wouldn't have a spear tip on it. And the whole idea was to show who was the best man, who could unhorse the other guy, with great, to watch. Wasn't intending to kill him, just wanted to, do a little one-upsmanship. I'm a better man than you. Excuse me, ladies, but that's what it was in those old-fashioned days. See who was the best person. Well, that goes on in healthcare, unfortunately, sometimes, and we call it medical jousting. And it's really the unnecessary, inappropriate, unwarranted, uninformed action, basically uninformed verbal response. And a lot of people call this another valuable gift. Medical professionals donate to lawyers. Once you found in the chart, jousting in a chart, it looks great in court. Now remember, when you go to court, you all are trained as scientists. You put this chemical together, add this chemical, you're going to get this reaction. I mean, it's a scientific thing, and thank God for it, because I want you to be very well trained scientists when you work on me. The law doesn't work like that. The law doesn't work like that. And I have an MJ degree. I can tell you that the study of the law is a lot more intellectually stimulating and rewarding than the practice of law is. The practice of law is not. So when lawyers take your case to court, they're not trying to decide scientifically right or wrong. They're trying to influence 12 lay people who know nothing about medicine or virtually nothing about medicine, emotionally get them to rule against you, the physician. Is that fair? No. Is that the way it is? Yes. That's why communication, documentation, risk management, patient report is so important. A study found that 25% of medical malpractice suits were traced to some critical remark made by one doctor against another. Unless your brother-in-law is a plaintiff's lawyer, there's no logical reason why you should be helping the plaintiff's bar out. Also, when you're reviewing the care of a prior physician, remember your body language too, the scowls on your face. He did what? Very, very. The patient reads everything, your body language especially. This, I really love this. Another one, real case. Female patient evaluated for surgery. The specialist, the surgeon, advised for surgery, was ready to do surgery. The referring physician, probably a generalist, internist, said, no, I don't think this patient is really up to the surgery. I don't think they're good. Well, the surgery's done, post-op complications, death. Now, the referring physician put this in the chart. Although I strongly disagreed with Dr. Green's proposed surgery, he convinced the patient to proceed. Her many post-op complications and finally her death have proved my advice correct. Now, how do you think that looks in the courtroom? Because that's going to be blown up even bigger than that, shown to the jury. One-upsmanship. Now, the problem is now Dr. Green's going to get even. He's going to have an opportunity to counter-joust. And we're going to have a jousting war going on. And LAMMICO has been called into hospitals where they were having jousting wars. And the plaintiff's bar was just reaping great benefits from it. Now, sometimes small notes can also do the same thing. Here's some, for example. A consultant should have been called. As usual, no nurse is available to help. You can see the physician's frustration here. I understand, but the nurse did not check on this patient. The catheter should have been checked more often. So be careful of the wording, And also, it used to be just in the written chart, but now we have electronic medical records. We have these small messaging devices. You all have them in your pockets right now. They've probably been buzzing the whole time I was talking. All right, these texting, emails, all the social media, Facebook. Be careful. Anything you say on these can be subpoenaed, can be used against you or a colleague in court. Be very careful of your wording. don't pontificate. If you want to pontificate, do it in the doctor's lounge among yourselves. And best thing to do it as a part of a review and a learning situation, not just to pontificate. Now, what about claims? Let's talk a little bit about claims. Dr. Griffin didn't tell you, but I'm a history nut, so I could go all day talking to you about the history of medical malpractice. It goes all the way back to 1200 BC. I'm sure that you would all be dead on the floor by the time I got finished, but I would have a great time. But I won't do that to you, but it goes back to 1200. Medical malpractice has been considered recognized wrong for a long time. Definition varies by state, and I'm going to cut it real short. Basically, it's breach of the standard of care that you would expect it under the circumstances. A breach of the standard of care. Now, who gets to decide the standard of care? Well, that is decided ultimately by the trier of fact. Who is the trier of fact? The court. And who does the court rely on? Unless you're having a judge trial, it's going to be those 12 jurors, lay jurors. So we, who are defending you, bring in our experts. We'll bring in people like Dr. Griffin to testify what the standard of care is under these circumstances. Then the plaintiff's lawyer will bring in somebody from New Jersey or wherever he can find them or she can find them who will testify that no, the standard's not here, it's up here, and obviously she breached or did not rise to that level. And then ultimately the lay jury gets to decide. See why I say it's not a scientific endeavor? Even still, we win about 95% of the time when we go to court. It's a great compliment to how well you've been schooled at these medical schools and what a good job you're doing. But even winning is not fun. It beats the heck out of losing. Medical malpractice is basically based on the concept of negligence. All professionals are held to that standard. But the important thing for you is that it's a tort. It's a civil wrong as opposed to a criminal wrong. And there's been some efforts to criminalize medical malpractice in many areas, but thankfully that hasn't been the case. It's a civil wrong which can be redressed by awarding damages. What is damages? Money. Okay, that's the way you address it. There's intentional tort, strict liability, but medical malpractice falls under the heading of negligence. Louisiana, those of you, how many of you all are not from Louisiana? Okay, probably you're all from a common law state. Louisiana is a civil code state, tracing our heritage back to the Roman law, or some of you would inappropriately say the Napoleonic Code, but really it's back to the Roman law. But we have our Medical Malpractice Act. We used to call it Act 817, and we still do, but it was Act 817 back in 1975. Dr. Griffin, I'm sure you were part of the effort to get that act passed. Well, it provides several things here in Louisiana. The state that you go to is going to be different. Every state is unique and they're different. But here in Louisiana, we have a medical review panel. Before a claim can be filed against a physician or any other healthcare provider in the state of Louisiana, if you're part of the PCF, which we'll talk about in a minute, then you get a review by medical experts, physicians that will review the case. They review the records of the case. And it's to provide an objective and fair appraisal of the circumstances surrounding the incident. The law also established a patient's compensation fund, fondly referred to as a PCF. The patient's compensation fund has it acts like a secondary insurer, and I'll show you that in a second. It provides a cap on medical malpractice claims. Louisiana, the most the plaintiff can acquire for damages is $500,000. That's where it's capped. Now we've got some future medicals that add on to that, and we've got interest, that type of thing that adds on to it, but it's capped at $500,000. Very important part. Again, the PCF functions. It's a quasi-state operation, and I'll show you how it's funded in a minute. But the provision of the cap is no damages awarded shall exceed $500,000. So if you have a jury, the runaway jury type of thing, where they come back with a $10 million judgment against you, if you're so unfortunate to be on the receiving end and the losing side, the judge then will reduce that $10 million down to the $500,000 cap. Now, the important thing for you is that the health care provider qualified under this act, and if you buy insurance, we qualify you under the act, so you're part of the system. Your personal exposure is only $100,000. No other state has that. So the most I, as a plaintiff's lawyer, could go after you for your whole estate is $100,000, assuming you're qualified under the act. And of course, you were smart enough to purchase coverage, or else your institution that hired you provided the coverage for you. Very, very positive thing here in Louisiana. Now, future medicals, 1975, the cap was set at $500,000. Do you know why it was set at $500,000 back in 1975? Because, wow, we never had a claim go above $300,000, so we'll set it at $500,000. That'll cover it. You know what $500,000, 1975 dollars would equal in 2015 dollars? Somebody take a guess. 5 million. Well, you're a little bit, but it's close. It's 1.5 million. 3 times. So, you know, when you look at this, well, that's not equitable, and courts are big on equity, you know, and they say, gosh, that's not fair to do that to a patient who is going to require help, you know, care for the next 20 years. $500,000 is not going to cover that. So we went back, smart folks at the State Medical Society and the other society went back, and we added the future medicals to the bill. So the PCF, not you, but the PCF will pay for continuing care of a patient. So I used to be a risk manager at Woman's Hospital in Baton Rouge. We'd have a, quote, bad baby. That's a horrible thing, but a bad baby where you've got a real damaged baby and it's going to require institutionalized care for maybe 20 years or more. Well, you know, you're going to run up into a lot of money. Well, the PCF will pay that care each year. The family submits the bill to the PCF and the PCF pays it. Once you settle, you're out of it. It's up to the PCF to handle all that, so you don't have to worry about it there afterwards. Quickly, the cap. You in Louisiana, again, remember, whatever state you go to, you got to decide what they have. I think in Texas, I think it's $250,000 that I forget exactly. I'm sure Tara would know, so y'all can talk to her or Diane. But here in Louisiana, you're responsible for the first $100,000 if you participate. Had a lot of nurses used to come to me with their $75 a year medical or nursing malpractice insurance. They say, well, am I covered, Ron? And I tell them as a hospital risk manager, say, well, yeah, you're covered, but you're not participating in the PCF because you haven't paid the surcharge to the PCF. So, you know, you have unlimited exposure. So you buy your first layer, the $100,000, and then the PCF takes over. So if we have to pay, your insurance carrier, whoever they are, has to pay the first $100,000. If the judgment is above that, then the PCF takes care of paying that up to the cap of $500,000. Again, you got to remember that judicial interest and expense, a lot of other things are figured into that, but that's basically the schematic of what we do here in Louisiana. The process for the medical review panel, A lot of debate on whether or not this is good or bad, whether or not it reduces the number of claims. Some people say it does, others say it doesn't make any difference. Generally, I think most physicians like the panel process, even though they have to serve on it sometimes against their will, maybe, because they had to spend a lot of time with it and with very little pay. The physicians get about $300 for serving on the panel. The attorney chairman gets $2,000. Who writes the laws in the state of Louisiana? Physicians or lawyers, huh? But at any rate, before a claim can be filed, it has to be submitted to the PCF, a panel, it has to be impounded. It's a request for a review. It's not public. It's not like a court case that you can go and pull the information. And it includes names, dates, specific allegations against the physician. And when that is filed, the prescriptive period or the statute of limitation, which is running, ceases until this is over. No action against the health care provider or his insurer can be commenced until all of this is completed. And the process, if the two parties agree, you can waive the panel or you can expedite it. Now here's how it's supposed to go. Mutual agreement, you pick a physician to sit on the medical review panel. The plaintiff picks a physician. Those two get together and pick a third physician. Then the record is reviewed. All right. The defendant has 15 days to appoint their health care provider. The health care provider appoints the two. The two get together, get the third one. The claimant shall have 45 days in order, once this is done, in order to pay a filing fee of $100 per physician named. Very important. Used to, all the plaintiff's attorney had to do was just go down and say, I want to sue this row of doctors, and submit it. And that's all. It didn't cost them a thing. And this row of doctors had to go to their insurance company and get lawyers to defend their interests. Well, what we did a while back, went to the legislature and said, well, look, every time the plaintiff names a physician or healthcare provider, other healthcare provider, he's got to pay $100. He said, what's $100? Well, one case at LAMMICO we had where the plaintiff's lawyer filed a claim against 30 physicians. Wow. Every one of those physicians cost money to defend. Every one of those had to go through. And they had no real reason to be in the in that claim. Well, with the $100 filing fee, the plaintiff's lawyer, they back off now. They only charge the ones that are most likely to give them good returns. All right, the panel has 30 days after review of evidence. This is often, I'd say most time, delayed. The panel decision would be made no later than 12 months after the notification of attorney chairman. Decision will be. Basically, this shows two things, but really there's three things that the panel will decide. Defendant met the standard of care. Defendant did not meet the standard of care. There's also a third, which is there's a question of fact that the panel is not competent to decide upon. And by that I don't mean there's a medical issue they're not competent. It's a legal question. For instance, the informed consent, was it properly drafted and executed? Those are questions of fact that have to be decided by the trier of fact. That's very seldom that occurs, but it is a third thing. But basically we're using physicians to determine whether or not the standard of care was met. And I would say about 80%, 90% of the time, we win the panel. Unfortunately, winning the panel is not a bar against filing the suit, but it is now admissible at court. And a lot of plaintiffs' lawyers will then look at that and say, well, if I can't find someone to testify against these doctors, I'm just going to drop it. A lot of times the family will say, well, okay, I've had a fair hearing, I don't want to go any further, and it's dropped at that point. So there are good points about the panel process. It does add a little more expense. talk about the statute of limitations. Those of you who are common law jurisdictions, so that would be every state outside of Louisiana, you know the term statute of limitation. It's the law that bars the claim after a certain period of time has passed by after the injury. It's the statute of limitations. It used to be in Mississippi, they may have changed it, but if you deliver a baby and there's a bad outcome, the statute of limitations was 18 years plus 1. So that OBGYN had 19 years in Mississippi to wait to find out whether or not he or she was going to get a claim. It's a little different than that in Louisiana. Louisiana, we have what we call the prescriptive, and again, that's the civil code that we go by, based on two things that I could talk all day about, but I won't worry you, preemption and prescription. Basically, in Louisiana, the prescriptive period for your purposes is like the same as the statute of limitation. Please don't tell any lawyer I said that. But the claim for medical malpractice can be made within 1 year from the date of the medical malpractice, so the date of the surgery, or maybe something went wrong post-op, 1 year, or within 1 year of the date that the patient knew discovery or should have known of the medical malpractice. For instance, if you remove the wrong kidney, I know right away. The next day, finally, I know that malpractice can be alleged. Okay, that's no problem. If you remove the correct kidney, but left a sponge in, and I don't find out about it till 12 months later, at that point, the clock starts running. I've got 12 months to file the claim. In no case in Louisiana can it be more than 36 months, 3 years. So if I find out about this sponge 37 months after, hey, my loss. I don't get a claim. The doctor's off scot-free. The prescriptive period in Louisiana and our informed consent statute, as well as our cap on damages, are excellent defense that physicians have here in Louisiana. Are all suits equal? Well, no, they're not. Remember, just because you get a claim doesn't mean that there's a breach of the standard of care. Just because you do not breach the standard of care does not mean you won't get a claim. Okay? Matter of fact, most claims, the majority of them, there was no malpractice. We like to call these frivolous lawsuits. If it were judicial definition, it's not a frivolous lawsuit. You and I, if you get sued for something you know you didn't do anything wrong, all your peers know you didn't do anything. All the experts know you didn't do anything wrong. That's a damn frivolous suit, ain't it? But from a judicial point of view, no, it's not. The judicial definition is that the party, the attorney or the plaintiff, they were aware that there was no merit or no supporting or no factual basis for the claims. The patient's perception is their reality, and that's where most of these without medical merit claims come from. They're not frivolous in the sense that you can sue for filing a frivolous claim. Now, you can file a suit, but you won't win it under this circumstances for frivolous lawsuits. Here's the most common type of without medical merit claims. What you would call a frivolous claim, but it's without medical merit. Patient not satisfied with treatment, patient angry due to adverse medical event, medical care did not meet expectations. Sometimes we overstimulate the patient with, oh, I promise you, I guarantee everything's going to be fine. I've done hundreds of these. I've never had any problem. Be careful. That unrealistic expectations will also put you in this situation of getting one of these without medical merit claims. Family unhappy with patient care. Perception. The perception of patient desertion, devaluating patient views, lack of physician concern. This is a perception, and remember, the patient and the family's perception is their reality. I did a study of about almost 1,000 depositions, reading from the patient, why did you sue the physician? And these are the most excuses I got right here. That perception that no one ever talked to me. They didn't care. The doctor didn't care about me. I don't believe that, but that was their perception, so it's very important. Again, poor or no communications. Avoiding the claim is a lot more rewarding than winning the claim. All right, documentation. I know. Risk Management 101, document, document, document. But documentation is so important, whether it's your office policies, processes, tracking, patient exams, family discussion. All of these documents will be reviewed with a magnifying glass by the plaintiff's lawyer. Very important that it's done and it's done right. Now, records that create questions of fact, things that the plaintiff's lawyers like to grab hold of, are inaccurate or incomplete records. Subjective, where you pontificate or editorialize in the record. But the biggie, the one that will destroy you the quickest, is alterations, when you change the record. In the old days, we used to tell people, don't white out anything, Well, now we got electronic medical records, and depending on the system that you're using, some of them are like a word processor or a word where you can backspace and retype over it, and you say, it's gone now. I changed it. The metadata is there. There are actually forensic IT people who specialize in reclaiming stuff that people thought was erased. Yeah, so remember, your alterations, there are ways to make correction in your notes, add addendums to your notes. Make sure you follow that process. You don't want to have the appearance, because your record is the very basis of your defense. When the jury goes in the jury room to deliberate, would you like to go with them and explain what you meant and what this means and what that? Wouldn't you like to do that? It would be nice, wouldn't it? Are you allowed to do that? No, you're not. Your record, when it's submitted into evidence, goes back to the jury room, and it can testify on your behalf if you've done it right. It'll testify against you if you've done it wrong. Remember that your record is back there, and the juries really do take their duty serious, and they really try, because quite frankly, they all have a very high opinion of physicians, and they want to find the physician correct because they view you as they view their own personal physician. Very, very important. This is a plaintiff lawyer's quote in one of their How to Sue Doctors, and he said, don't take cases where you don't have any medical records to back up the plaintiff's claim. So you want something to back up the claim or make the defendant physician look bad. One of my favorite things, we lost a case at Woman's Hospital because one of the OB doctors, GYN doctors, was so frustrated with this lady that kept coming back with STDs. He treated her and she'd go come back. She treated her and she'd come back. And just out of exasperation, he wrote in the chart, this woman's estrogen level is higher than her IQ. Ooh, that was so bad. And he felt so good. That went up on the wall. Now, what do you think the jury thought about that position? Again, be careful. The plaintiff lawyers look for stuff like that. All right, I got about 8 minutes to go over insurance. Professional liability insurance, it's got many names: PL insurance, medical professional malpractice insurance, and it's to important factors as you got the amount of coverage. Make sure you read your insurance policy. Now, if you're working for the VA system or the state, you got coverage. But if you go out and you have coverage on your own, or you go with a group and they purchase the coverage for you, you get a copy of that policy and you read it. Understand what the limits are. Understand who's covered. Any deductibles on here, any additional cost that's due to me. When and where does the coverage exist? So all these things are important, and you have to read the policy. And it's like sticking needles in your eye reading insurance policy. I promise you, because I have to read them myself. I know. 2 terms, indemnity and expense, very important. Your 100,000, 300,000 coverage here in Louisiana, which is a basic coverage. You can get more, but that's your basic coverage. It applies to indemnity only. Now you're going to have times when your expenses in Louisiana are more than the indemnity payment. So make sure you understand that. The 100 means that's your first 100,000. That's what we pay before the PCF kicks in. The 300,000 means that in any policy year, this insurance company will pay 300,000 for claims brought against you. So if you have 3 $100,000 claims, which is sort of hard to happen, but if you do, we'll cover it. If you have the 4th claim, it's on your nickel. Okay? Very important. That's that 100,000, 300,000. If you go to Mississippi, they sell 1 million, 3 million, because they don't have a cap. So, but that's the slash. The 1 is for the first layer. The second is for what we'll pay maximum within a policy year. Let's look over here. What's covered? Policy coverage for medical activities, your usual practice, that's fine. But if you get into some specialty area, make sure your underwriter knows the treatment methods. Telemedicine is really, really big issue now. So if you practice telemedicine, make sure your underwriter, the person that you got your insurance from, either the agent or the underwriter, understands that, oh, by the way, I'm doing telemedicine. Oh, and by the way, it goes all the way. We go to Iowa, we go to Texas, we go all over the country. You may have issues. Do you have a license in each one of those states? That's outside of the medical malpractice arena, but you want to ask those kind of questions. You want to make sure your carrier will cover you, because some carriers write policies that will cover claims originating in this state. Well, if the claim is in Kansas and you're doing teleradiology, you may not have coverage. So you want to find that out before and not after. Here's some of the things that contribute to the cost. If you're in surgery, you're in the surgery class, which class 6 now? What's surgery class? Class 5? Okay. But anyway, you're by class. So you're not individually rated. It's not like automobile insurance where, if this driver has a good driver record, but he has a horrible driver record, this gets a cheaper premium, that gets a higher premium. That's not the way it happens in medical malpractice. The class, all surgeons get the same base rates. Now, there are surcharges if you're 1 or 2 standard deviations above the mean for your group, but generally speaking, you rise and fall with your class. Surcharge, again, for above average risk. A quick note, in Louisiana, the PCF calls their premium a surcharge. In insurance, when we charge that high-risk doctor more, we call it a surcharge. 2 different things, okay, depending on who you're talking to, PCF or the insurance company. Deductibles, discounts, all these are important to look at. And we'll finish up talking about occurrence versus claims-made policy. Y'all remember this. It's in your handout. Very, very important. This is where you may or may not have coverage. You want to make sure when you're moving from one policy to the other. Professional liability insurance, the occurrence policy, and it'll usually be stamped in red at the front of the policy, occurrence or claims-made policy. If it's not, you ask your risk manager, your agent, your underwriter, what kind of policy is this? Is this occurrence or claims-made? The occurrence, whether or not the trigger for coverage depends on the date of the event. It must be within the policy period. So coverage then applies no matter when the claim is made, just as long as the incident occurred back when the policy was in effect. And it's typically more expensive. That's why most, especially just getting started, will go with the claims made policy. The trigger there depends on when the claim is made. The event date must be after the retro date, or basically, if you're with LAMMICO, for instance, or CNA, for instance, and on year 1 you pay, year 2 you renew, year 3 you renew, year 4 you renew, and then you get a claim back to year 1. Well, because you renewed each year, we did what's called a retro date. We take it back each year. That's more than you want to know, but the main thing is you got coverage. Even though the claim was made, the policy was still in effect. Very, very important. I'll have a little schematic to show you a little bit about that. Tail coverage is the vernacular. It's an extended reporting endorsement. That's for claims made policy. It's the extended reporting period. So if you leave a claims made policy, you have to purchase, I don't say you have to, but it is very wise to purchase extended reporting coverage so that after you've gone, you're not renewing that policy 2 or 3 years down the road before the prescriptive period in Louisiana or statute of limitations in your common law state has run, and you get a claim. You're no longer with that policy. If you don't purchase the tail coverage, you'll be naked. It's all on your nickel. Very, very important. You can also purchase, if you're a good risk, another reason to be a good risk, you can purchase nose coverage, which is prior acts, which is offered by the new insurance. So I'm negotiating against another insurance carrier, and I want you on my policy. And he said, well, I got to pay the tail. I said, well, I'll give you nose coverage. Why? Because you're a good risk, and I want you on my book of insurance. Or you can purchase the nose coverage. All right, let me do this and we'll be finished. Here's the idea. Purchase policy, claims made. Had an incident in 2014. Policy in, I went off to Bogota, wherever. Patient filed a claim. Don't have coverage unless I purchase tail coverage. If I purchase tail coverage, I've got coverage. Whereas on the occurrence, purchased the policy, left it, an incident occurred in 2014, then 2016, a patient files a claim. It doesn't matter because the claim occurred while I still had the policy, even though I was in Hawaii with a totally different company. All right, I think we've ran out of time.
Everybody has a question. We covered the podium. A lot of my time is used up. You get CME credit today if you signed up here on this form up here. They're going to do copies.
And there's a blue evaluation form. Please fill that out for me.
Where are they located?
They're in the back of the handout. In the back of the handout. That's to prove to my boss that I was up here, also my wife, that I was up here working and not playing with the grandbabies.
Thank y'all for coming.